Thank you very much, Casey, and good afternoon, everybody. Thank you very much for joining us today on this Authors Guild and Copyright Clearance Center webinar. My name is Michael Healy. I'm the Executive Director for International Relations at Copyright Clearance Center, and I'm based in CCC's offices in New York City. Thank you again for joining us. As Casey has mentioned, this webinar is scheduled to run approximately 90 minutes, and we're going to leave a significant portion of time towards the end to allow participants to ask questions. And that will be, as Casey said, using the dialog box which appears at the bottom of your screen on the right. This afternoon's session is focused on recent international developments in copyright and licensing. My responsibility here at CCC is to manage the company's international relations. What that means in practice is that I'm responsible for a series of relationships with counterpart organizations very similar to CCC around the world. As you know, CCC is a reproduction rights organization or a collective management organization, and there are counterparts to CCC in many, many countries around the world. In fact, something north of 80 countries have reproduction rights organizations, and with most of them, Copyright Clearance Center has bilateral or unilateral relationships. And through those relationships, royalties flow to CCC, which we pass on to publishers and to authors. Now, my responsibility and my team's responsibility gives us a certain vantage point from which to look at copyright and licensing around the world. We spend a great deal of our time overseas, interacting with organizations very similar in many respects to CCC. And as I say, that gives us a position from which to see what is happening to copyright and what is happening to licensing conditions around the world. You may ask, well, what does it matter? Why do developments in copyright and licensing in a place like South Africa or the Middle East, how do they possibly matter to American rights holders? Well, the clue, of course, is in the information I gave a moment ago. Those royalties that are flowing into the United States, which CCC passes on to rights holders of all kinds here in the United States, they can be very dramatically affected by conditions happening around the world. Those conditions can be things happening inside governments, inside courtrooms, and inside legislatures all around the world. So what we're going to try to do this afternoon is to spend a little time talking about those conditions and how they might affect rights holders here in the United States, whether they be publishers or authors. I should stress from the beginning that I'm not an attorney, and this isn't a legal presentation in any sense. I'm not going to be telling you much about copyright law in Sweden or South Africa. What I am going to tell you about, I hope, is the commercial conditions that prevail around the world in some of the leading countries and how they might have an impact or at least an influence on what you do. So we're going to start by talking a little bit about the context. And by that, I'm going to talk about the legal conditions that prevail currently in various parts of the world. Many of you will know that it's a nonsense to speak of international copyright law, as if there was one single legal regime affecting copyright or influencing copyright. That's simply not the case. By definition, copyright law is national in scope. The conditions affecting the use of content here in the United States, those conditions are set by American law. That is equally true in other countries, in the United Kingdom, or indeed anywhere else around the world. National law is what prevails when it comes to the conditions that affect the use of content. Yes, there are international treaties, absolutely, and we're going to talk a little bit about those. But the existence of those international treaties is not the same thing as saying that there is a single international copyright law. There simply isn't. So the principal point I'd like you to keep in mind as we go through these slides and this presentation this afternoon is that copyright is national in origin and in its application. So the Copyright Act of 1976 here in the United States, that is what governs the use of content and how copyright affects that content here in the United States. So the law of the country where the use takes place is what really matters. So when you hear about precise legal terms related to copyright, such as fair use in the United States or fair dealing in a place like Canada or the UK, those are provisions which were born in a particular country and which apply to a particular country. So it makes sense only to talk about fair use in the United States. It makes no sense to talk about an exception called fair use in any other country where there is no fair use provision within the national law. So when you think about copyright law, think about it mainly as national copyright law. Nevertheless, as I mentioned a moment ago, there are some important treaties in place, and the purpose primarily of those treaties is to provide some measure of consistency around the world and in the dealings between individual countries. Many of you, I think, will have heard of the first international treaty visible on the screen, the Berne Convention. This is without doubt the first and most important treaty related to intellectual property and specifically to copyright. It's also the oldest. It was created first towards the end of the 19th century and was first formally introduced, as many of you will know, in 1886. It took a long time for the United States to sign up to the Berne Convention. In fact, a little more than 100 years had to pass before the United States joined in, and I think it was back in 1989, in fact, that the US signed up to the Berne Convention. Now, the great value of the Berne Convention is the fact that it provides a standard, a minimum standard, if you like, of copyright protection that unites all these different countries. One other important thing to know is that the Berne Convention applies the principle of national treatment. And with hundreds of countries, and therefore hundreds of different copyright laws, the important part of when you come to think about national treatment as a principle is that it's essentially a principle is that within an individual country, you treat someone else's work no worse than you do your own. So, for example, the provisions applicable to content generated in the United States must apply when that content is used in the United States from another country. For example, content produced in France when used in the United States cannot be treated any differently and certainly no worse than a piece of US content would be treated. So that essentially is the principle of national treatment. I'm sure many of you will have heard of WIPO, the World Intellectual Property Organization. This organization is based in Geneva in Switzerland and operates within the framework of the United Nations. It was established and set up in 1967, and its primary purpose is to promote the worldwide protection of intellectual property, and specifically to do that through cooperation between member states. So the World Intellectual Property Organization, set up, as I say, in 1967, established a common intellectual property framework for copyright, trademarks, and patents between those countries that are in membership of WIPO. It also set up a system, or several systems, to protect and enforce intellectual property rights. There are lots of those systems. We're not going to cover them this afternoon, but you can find a great deal more about the work of WIPO at the World Intellectual Property website. Suffice to say that one of its responsibilities, one of WIPO's responsibilities, is to administer the various treaties, the international treaties. These include the Berne Convention, which I talked about a moment ago, and they also administer individual treaties on trademarks and patent law, and also treaties dealing with various internet-related activities, including the transmission of content, the removal of DRM, and various other things. So in our world, in my world, WIPO is a very important organization for its administration of the international treaties that underpin copyright and provide some consistency for copyright around the world. While we're on this very brief tour of international treaties, it's worth mentioning TRIPS. Again, this is an acronym that you may have heard of previously. If not, TRIPS stands for Trade-Related Aspects of Intellectual Property Rights. And it's an agreement that was entered into and came into force in 1996. TRIPS incorporates effectively the stipulations of the Berne Convention, adding things like computer programs and databases among the classes of protected works covered by the Berne Convention. People say TRIPS also adds what they call teeth to the Berne Convention by putting in place and by implementing effective stipulations relating to the enforcement of copyright and other types of intellectual property rights. So that's a very quick review of the various international treaties relating to intellectual property and specifically to copyright. But as I said at the beginning, the existence of these international treaties, important as they are, should only serve to remind us really of how national copyright legislation in fact is. Moving on, just as copyright systems, copyright regimes are national, the same is true of licensing systems. If you look at the bottom of the screen there, to the third bullet point, voluntary licensing, if I can take your eye there for a moment, the reason I do so is that here in the United States, we operate under an entirely voluntary licensing regime. So the rights that Copyright Clearance Center exchanges with reproduction rights organizations around the world, we're able to do that only because we have collected the rights from individual rights holders on a voluntary and non-exclusive basis. So every one of the rights that we include in the licenses that we sell, whether those licenses are sold to corporations or to academic institutions, we have collected one by one from the rights holders on an entirely voluntary basis. Now, voluntary licensing of the kind I'm describing now does exist in other countries, but it's surprisingly unusual, in fact. You'll see a couple of countries that I've listed there alongside the United States, notably Japan, Ireland, the Philippines is another one. In these countries, licensing is not statutorily based. It's not imposed by law. It's done on the basis of voluntary agreements between two or more parties. But as you can see further up the screen, statutory or compulsory licensing does exist in many, many countries around the world. And where you find a statutory or compulsory licensing regime, the licenses are fixed by law. You find this kind of licensing scheme in many parts of the world, but it is particularly prevalent in certain regions, notably Scandinavia. And for the sake of completeness, you ought to be aware, too, of a third major type of licensing system, which is the levy system. And here we find a system which is essentially based on taxing machinery and media that can be used to copy content. So in many countries around the world, when a photocopying machine is sold or a scanning machine is sold, part of the proceeds are effectively a tax, and that tax is remitted to a collecting society or a reproduction rights organization, and those taxes ultimately find their way into the hands of rights holders, whether they be authors or rights holders of publishing companies, or both. The levy system, quite well established, is found in many, many parts of Europe, and it has been established for quite a long time in those countries. It is, I think, fair to say, a licensing system increasingly under threat. I'm going to talk a little bit more about this later in this afternoon's WebEx. But in countries in Europe, such as Belgium and in Germany, recent developments, both in legislation and in litigation, are threatening the future health of the levy systems. And there are many very well-informed commentators who believe that over time the levy system is going to disappear in some countries, and that the revenues that have historically gone to authors and publishers from those systems will eventually themselves be threatened or disappear entirely. So that's a very quick overview of those systems. Whether they're statutory, levy-based, or voluntary, many, many collecting societies, as I said at the outset, manage these schemes around the world. And currently, I think we have something like 85 reproduction rights organizations around the world responsible for administering the kinds of schemes that I've summarized on the slides that you can see on your screen. So let's move on from here. And as a means of getting us into the second part of our conversation, which will focus on what is happening with copyright around the world today, I thought it might be useful if all of us took a look at copyright as we've known it for many, many years, and the value proposition that many of us associate with copyright when we think about it. Now, when I started my publishing career more than 30 years ago, the only people I remember hearing talk about copyright were academics and attorneys. I don't remember a single commercial leader, a CEO, for example, in any of the publishing companies I ever worked for, talking about copyright. Its place as a foundation stone of our industry was taken for granted. It never felt particularly threatened or imperiled in any way. But of course, that's all changing now. We took for granted that copyright did certain things. It conferred, effectively, a time-limited monopoly on those who created content, whether it be authors or publishers or others. And that time-limited monopoly had a number of effects, valuable effects, we thought. It encouraged creativities, whether it's among authors individually or indeed publishers. It provided a means of rewarding creators and incentivizing them to do further work. It was a critical part of the process of developing scholarship and therefore supported the dissemination of knowledge in schools and universities and colleges. It offered protection to the content produced by authors and some measure, therefore, of content to the owners of that content. It was, in other words, a critical piece of a critical stone, if you like, or brick in the cultural framework in which we all operate. And not least, of course, for any modern, vibrant publishing industry, copyright was a foundation stone on which that industry was built. And for many of us on this call, we were in a fortunate position of taking much of this for granted. Nobody was seriously questioning the value of copyright and the contribution it made to teaching, to learning, to scholarship, to publishing, to authorship. All of those things could safely be taken for granted. But in recent years, those foundation stones have been shaking. And now we've moved from a point where only academics and lawyers talked about copyright to a position where copyright is front-page news to some degree, and that's no exaggeration. Copyright is the subject of a very high-profile public debate, and it's an intensely politicized debate as well. We, of course, are exposed to it here in the United States, but we could be having this conversation almost anywhere in the world, and we would recognize the features of the debate because it is truly global. And the final thing I would say about the debate, as you can see on the slide here, not only is it high profile and public, but it's extremely polarized. There are constituents arguing quite seriously for the abolition of copyright in its entirety. There are legislatures around the world with political parties represented that advocate piracy. And many of you will know within, for example, the European Union and in the European Parliament, the Pirate Party has representatives, and that's true in other individual national legislatures around the world. So we're living and working in a time where we cannot take the future of copyright for granted. And as we move through this presentation this afternoon, I'm going to be pointing to a number of individual countries in which the future of licensing, the future of copyright is significantly threatened. And we'll be talking about some of those cases in the course of the next few minutes. So if there's a debate about the future of copyright, what kinds of issues and questions are being debated? Well, the first thing to say is that it's not just copyright that's within the crosshairs of those who would like to see intellectual property taken apart and possibly reassembled. Other types of intellectual property are equally challenged, including trademarks and patents. But I think it's fair to say that copyright specifically is the #1 target of those who would like to see a much more liberal regime in place. And those who argue in favor of loosening copyright laws point, of course, to a different economic base than the one we've been used to. All of us now are living in a world, of course, where tangible assets have become to some degree less important than intangible assets. And we talk a lot about the creative economy and the contribution that creative contributors make to the economic health of the world, whether it's musicians, film producers, authors, software engineers. There's a great appreciation of the economic value that creators contribute. And that, to some degree, combined with enormous technological change, is causing many people to question the appropriate type of copyright that needs to exist in the future. Technology change, it's hardly necessary to talk about it in some respects, but take, for example, the social media tools that all of us use every day, whether it be Twitter, Facebook, or in countries like China, something like WeChat. These social media tools are essentially content sharing tools. And they can be seen as opportunities to infringe copyright by unauthorized sharing of content across social medias. Now, the difficulty here, of course, is that every facet of our lives is changing, whether it be our working lives, teaching lives, the ways in which pupils learn, students learn, and so on. Set against this background, you find a great populist voice arguing for reform of the copyright regime to make it easier for users to share content. And I always say that part of the clamor here is for widening the rights of content users. And I would argue that there's some imbalance in the debate today about the rights of users and the responsibilities of users. I find some of the imbalance tending to focus on the responsibilities of content owners, but the rights of content users. And I would argue that that balance isn't always properly achieved, either in the public discourse or indeed in the legislation that is often the expression of that public discourse. So we have this very vibrant, very polarized, very public debate, which is partly cultural and partly economic and partly social. And related to that debate, the argument is often made that those of us in the content industries, whether we be publishers, authors, or others, are partly responsible for the direction of this debate because we haven't put in place modern systems to make it easy to license content legally. And we're going to be talking a little bit more about that later in the presentation this afternoon. But one thing's for sure, the debate I'm referring to, whatever side of the debate you're on, one thing is clear, is that it's a debate to which government is listening very, very carefully. And as you'll see when we go through the rest of this presentation, governments around the world are responding in various ways to the debates that they see amongst electors. So, what is government's agenda in all of this? Well, there's no single government response around the world, as you can imagine. But you can, as you go from place to place and watch what's happening from government to government, you can begin to see certain trends emerging when it comes to defining how governments respond to this debate. Too often, in my view, there is an immediate legislative response to this debate which goes in the direction of introducing more and more exceptions to copyright and more limitations on copyright. And when we come to talk about how these changes have been implemented in different countries, you start to see a common thread running through the various responses in different countries. And that's an increasing number of exceptions to copyright and limitations on copyright being enacted in different pieces of legislation around the world. Most of those exceptions, most of those limitations are applied in the academic and educational space. And we'll come on a little later to talk about those. The other feature you see as you study the behavior of governments around the world is that they are expecting much greater degree of accountability and transparency on bodies that administer copyright and licensing. So organizations such as reproduction rights organizations, collective management organizations more generally, are now subject to legislation that emphasizes greater accountability and transparency in their dealings. And of course that ought to be welcomed. Organizations handling large sums of money that really belong to creators should have nothing to fear from a greater degree of accountability and transparency imposed by government. So the European Union, for example, last year published a directive on collective management organizations, and every member country, every member state of the European Union was required to introduce that directive into their national legislation by a fixed time. And the member states of the Union are currently busy getting that done. It's true to say also, I think, that many governments, particularly in the developed world, want to encourage better licensing mechanisms, better systems that allow it to allow licensing to take place that's easier, has less friction built in, and more transparent. And we're going to be talking about a few of those. But in the United Kingdom, for example, the government has funded the creation of something called the Copyright Hub, which is intended to introduce more transparent, more cost-effective licensing regimes for individuals and small businesses in the UK. And that's an example of how a government agenda has led to changes in the licensing market. And wherever governments talk about review of intellectual property or reforms to copyright, they often speak about introductions of greater simplicity and automation in the licensing mechanisms that prevail in one country or another. So that's the government agenda. So let's step back and think about this as content producers ourselves, as publishers, as authors, as creators of different kinds. It's easy to think that we're standing in the middle of what this slide calls the perfect storm. And by that I mean a collection of conditions, a collection of circumstances that, taken together, appear extremely hostile to the ongoing interests of authors, for example. So, on the one hand, you've got widespread, ubiquitous technology that makes it easier than ever before to share content, your content, without permission, without approval, and without payment. And you see the tens of millions, hundreds of millions, in Facebook's case, billions of users using these social media tools which appear to facilitate copyright infringement. We have also a public debate, which I've said earlier, I think is quite unbalanced. And sometimes the voices speaking most loudly in that debate are those arguing in favor of, if not just the loosening of copyright protection, then its abolition entirely. Faced with those circumstances, it's obviously vital that all of us stand up and argue in favor of copyright and what copyright contributes to the creative economy and what individual creators contribute to a prosperous economy. So there's an urgent need for greater advocacy. And much of that, of course, is articulated through trade associations. The Authors Guild, of course, has been a passionate defender and a very effective defender of copyright and the rights of creators for many, many years. And on the publisher side, that is true equally of the Association of American Publishers and many other trade associations in the United States and around the world. There's also a tremendously urgent need to educate consumers about copyright. I would argue, at least in my experience, that consumers' awareness of copyright is generally very low level indeed. What they're entitled to do and what they're not entitled to do, what they're expected to pay for, what they're expected to get for free, awareness is at a remarkably low level. And if that's true in the United States, you can be absolutely sure it's true in many, many other countries around the world. I have just returned from running a copyright education seminar in Beijing 10 days ago, a seminar that Copyright Clearance Center put on for university administrators, librarians, and lecturers. And I can assure you that the level of awareness of copyright, its purpose, its benefits, etc., among Chinese students is as low as I've seen it anywhere around the world. And that's true, I'm sorry to say, in many, many other countries. And perhaps the final feature of this perfect storm is that for people who want to do the right thing, for people who understand their responsibilities under copyright law, people who want authors and publishers and other creators rewarded, some of them are not in a position to do the right thing because in parts of the world, licensing services are simply not available. Here in the United States, we take for granted that the kinds of licenses sold by Copyright Clearance Center, whether they be annual licenses or repertory licenses or pay-per-use licenses or whatever, those licenses don't necessarily exist in other parts of the world. So take a region that I work in quite frequently, the Middle East. There is no functioning reproduction rights organization in any country of the Middle East today. I'm working with colleagues and partners in that region to establish the first reproduction rights organization in the United Arab Emirates, a highly developed country, a highly prosperous country, but no mechanism whatsoever for collective licensing, and therefore no means of paying the royalties either to local authors or to American authors or to British authors whose content is used in Emirati universities or wherever. So that's the final feature, if you like, of the perfect storm. Places where, for whatever reason, no licensing services are in place today. This is a very serious situation. And you'll recall me mentioning the World Intellectual Property Organization in my opening remarks a few minutes ago. And it's interesting to see this remark, which the Director General of WIPO, Francis Gurry, made some time ago. And it's worth repeating in full, I think. We need a global infrastructure that permits simple global licensing, one that makes the task of licensing cultural works legally on the internet as easy as it is to obtain such works there illegally. And what Mr. Gurry or Dr. Gurry is referring to there is the point I was making earlier. There are so many people, whether it be students, academics, corporate researchers, whatever. There are users who want to license, and there aren't always in place the mechanisms, the systems that enable them to do so. So, having made a number of rather general remarks, I want to turn now, if I may, to some specific instances that demonstrate the points I'm making. The first is the appetite amongst governments for reviews of intellectual property. These are very, very common. I've just put 2 or 3 on the screen there, but they are standard government responses to this highly public debate about the future of copyright. Might be worth focusing first on the United Kingdom, one I particularly know well. The government of the UK back in 2011 commissioned an academic called Professor Ian Hargreaves and asked him to generate a report addressing the question of whether the intellectual property framework of the UK was fit for purpose. By that they meant, did the framework of IP laws, whether they be trademark, patent, copyright, did they support the development of a modern economy, or did they obstruct, impede, inhibit a modern creative economy? Professor Hargreaves produced his report back in 2011, and he was highly critical of the UK government's legal framework. And when it came to copyright and to licensing, the primary recommendation of the Hargreaves Review was to recommend a further review focused on copyright and licensing specifically. And a man called Richard Hooper was commissioned by the government to take forward that specific review on copyright and licensing. And it was Richard Hooper's review that led to the establishment of the Copyright Hub, and that was initially at the time a government-funded non-profit organization intended to introduce more licensing mechanisms, easier licensing mechanisms, both for individuals, small businesses, medium-sized businesses, and so on. The establishment of the Copyright Hub, I think it's fair to say, was the primary outcome of the Hooper Review, rather than a very significant list of new laws. And to that extent, much of the recommendations made by the Hooper Review were welcomed by the content industries, I think, and much of the content industry gathered round to make a success of the UK Copyright Hub, which is still obviously in its early days. When it came to reviewing whether copyright law was fit for purpose, the Australian government took a leaf out of the British government's book and in 2015 asked its Productivity Commission to do quite a similar study on whether Australian law was fit for purpose in the modern age. And the Productivity Commission relatively recently has published its final report. It provoked enormous outrage and concern from Australian creators. And authors, publishers, agents, visual artists, many, many others have come together to condemn many, many of the recommendations made by the Productivity Commission in Australia. The Australian government has not yet decided how it's going to respond to the report of the Productivity Commission. None of us know yet the extent to which they will implement recommendations from the Productivity Commission. And I think it's fair to say that the creative industries in Australia are waiting somewhat nervously to see what the Australian government does. I put the European Union on this slide because there have been so many reviews of various aspects of copyright and intellectual property stimulated by the European Union and Commission that, there's too many to list, frankly, here. But it does feel as if the EU has been going through such a fundamental review of IP and copyright specifically for such a long time, and many, many changes are underway within the Union. Legislation often follows these government reviews, but sometimes legislation happens without any formal review of the kind I've been describing. Again, I've put on this particular slide just a handful of countries that I know well, or regions that I know well. I could quite easily have filled several slides with individual countries that have enacted new legislation. I tend to start with Canada. I don't know if any of you are dialing in to this WebEx from Canada particularly, but I tend to put it there because the Copyright Modernization Act passed in Canada in 2012 was one of the first pieces of modern legislation introduced, and without question, in the minds of many, the most damaging to the interests of content producers such as authors. You may have heard a great deal about it. It's been very, very highly publicized. And from the point of view of creators, particularly authors and publishers, I can't think of a piece of legislation that has been more widely condemned by authors and publishers, more routinely and consistently criticized for the damaging effects it's had on the interests of authors and publishers. Its purpose was to, as its name implies, modernize copyright for Canada and particularly for its educational sector. The problem with the legislation is that it has been widely misinterpreted, perhaps deliberately misinterpreted to mean that all copying in an academic setting can be carried out without remunerating authors and publishers. And there have been very, very many negative consequences to this piece of legislation. We certainly know at CCC of several independent publishing companies in Canada that have closed their doors simply as a result of this piece of legislation. Publishing companies that had relied on licensing revenues from the academic and educational sector that as a result of this act disappeared, went from whatever to zero. Now, at CCC, we have a ringside seat on what's happening in Canada because we see the licensing revenues that come from Canada to the United States that we distribute to American publishers and to authors. And I can assure you those revenues have fallen dramatically in the course of the last 5 years. We are paying significantly less in payments to American authors, American publishers, because licensing revenues collected from Canadian universities and schools are falling through the floor. So Canada, for many authors, for many publishers, represents how badly things can go if governments get it wrong. And unfortunately, the Canadian flu, as copyright people like to call it, is infecting many, many other governments and many other countries. There is draft legislation on the books in South Africa currently. Hasn't been passed yet, but we've seen it close up, and it's a variation on the Canadian situation. It proposes far-reaching exceptions to copyright, far-reaching limitations on copyright in the academic sector, And these exceptions and these limitations are unremunerated. By that, authors and publishers will not benefit from a widening of the copyright infringement or a widening of the copyright limitation. And the same is true in Brazil and in many other countries around the world. So there is a tide of hostile legislation, hostile to the interests of authors, hostile to the interests of publishers. And as I mentioned a moment ago, we could go on and on listing countries where provisions, whether enacted or in draft form, spell very, very bad news indeed for authors and publishers. Now, not every country is organizing itself to enact new legislation. And one thing we know from experience, all of us, is that if there is a legislative vacuum, lawyers and judges like to step in to the vacuum. And in many countries where there has been no new legislation, there has been very significant litigation as a result. I've listed here on the screen a few examples. Again, there are far too many to cover in this short presentation. They very often have the same battleground, which is the university sector. So I've put here, as you can see, a very high-profile litigation in which the defendant is Delhi University and the plaintiffs are three extremely well-known international publishers, Oxford, Cambridge, and Taylor and Francis. The battleground in this piece of litigation is photocopy shops on campus. At Delhi University and in all the Indian universities, some of you may be familiar with these, copy shops spring up all over the campus. And for tiny sums, these copy shops will photocopy chapters, sections, and indeed whole books for tiny sums of money. OUP, CUP, Taylor and Francis brought a case against the university and one of the copy shops for copyright infringement. The case lasted several years. It went through the lower courts, the higher courts, the appeal court, and at the end of it all the judges ruled in favor of the university and the copy shop. And needless to say, not one penny of the copying revenue was coming to publishers, authors, whether Indian or others. So that was a very serious and very damaging set of judgments for copyright owners in India. We see the same closer to home, of course, the Georgia State case, probably familiar to many of you. In some respects, similar to the Indian case in that the defendant is a big university. The plaintiffs are three well-known international publishing companies, in this case, Sage, OUP, and CUP again. And in some respects, but in a more modernized setting, the battleground is the same. You know, what are you entitled to do with copied content? In this case, it relates to electronic reserves and digital course packs and so on. This piece of litigation has been back and forth now for several years. It's still unresolved. And I put it on the screen here because the United States is a country in which there has been almost no modern copyright legislation. The last fully comprehensive Copyright Act here in the United States, as you know, is the Copyright Act of 1976. And a great deal of development has happened in those intervening 40 years. But I put this particular case on the screen because it exemplifies to some degree what happens when governments fail to introduce modern copyright legislation and the courts get involved. Academic settings, academic campuses and so on are not the only battleground. Those of us in the business of collective management of rights and collective licensing have been watching two cases in Europe very closely. The judgments in both of these have been very, very hostile to publishers. And if you cast your mind back to some of the early slides, when I was talking about equipment levies and licensing schemes that are based on essentially taxes on recordable media and scanning equipment and photocopiers and so on, here we have two cases active in that particular setting. The first was between Hewlett-Packard and Reprobel. Reprobel is the reproduction rights organization, the counterpart of CCC, if you like, in Belgium. And the second is related to our German counterpart, VG Wort, and Fergel, who was the plaintiff in that case. Again, I put them here because they're examples of a tide of decision-making, judicial decision-making, that's been quite damaging to copyright owners. VG Wort's case, for example, very complex case, but ultimately the judges concluded that royalties paid as a result of these various levy licensing schemes could not go to publishers. They could only go to authors. So essentially, that ruling denied that publishers were copyright owners for the purposes of distributing royalties and revenues from these levy schemes. So again, many, many examples that I could put on these slides. I could fill the slides with many, many more instances, but I've just picked a few of the most high-profile ones for this afternoon. So taken together, government reviews, legislation, litigation, what does this all add up to? What fundamentally is at risk here? Well, firstly, as you will have seen from the Canada example I gave a moment ago, the first thing that is at risk is licensing revenues that go to authors and to publishers. Formerly, millions of dollars were collected by the Canadian collective licensing organizations for remittance back to authors and publishers, whether they be Canadians, Americans, or wherever. And most commentators believe that those licensing revenues from academic users are trending in one direction, and that's to zero. And for smaller publishers and for authors dependent on academic licensing revenues, it's no exaggeration to say that the effect has been devastating, not just from Canada, but from elsewhere. And if we see more legislation of that kind, the consequences just repeat themselves from country to country. This goes straight to the pockets of authors and publishers. This is what's at risk. The principle of collective rights management itself is at risk, in my view. Collective rights management has a long and distinguished history of supporting the interests of authors and publishers since the 18th century, the late 18th century. But since the 1970s, we've seen the establishment of collective rights management bodies, and they are responsible for very, very significant revenues being distributed into the hands of authors, musicians, publishers, and so on, other content managers. Those organizations are at risk, and those revenues are at risk. And taken together, many believe that copyright itself, at least as we've understood it for many years, is itself at risk. And if I can put some numbers around this just for a moment, collective management organizations, when the numbers were last quantified back in 2013, had collected nearly 11 billion euros on behalf of creators. Most of that, the vast majority of that, of course, is collected by collective management organizations working in the music space. But in our world, the world of reproduction rights organizations like CCC, it's not a trivial sum even there. In 2013, it was 1.1 billion euros. And we at CCC alone are probably a quarter of that, because in 2015-16, the last year for which we have figures, we distributed to authors and publishers $218 million in that year alone, and we ourselves have distributed more than $1 billion to rights holders in the last 5, 6, 7 years, I think. So this isn't, in any sense, theoretical, abstract, or anything other than very, very practical stuff, if I can put it that way. So in conclusion, I want to give as much opportunity as I can for people to ask questions, but we're in a period of tremendous transformation, and much of that is led, of course, by technology. And that's unstoppable. What isn't unstoppable is the threat to copyright licensing and the revenues associated with that. But there's no denying that wherever you look in the world, those threats are real and very, very serious indeed. None of us can take this lying down. None of us are taking it lying down. I talked about trade associations, trade bodies like the Authors Guild and the AAP, and the association that my organization is a member of. CCC is a member of IFRA, the International Federation of Reproduction Rights Organizations. We're, all of us, busy making the case for copyright. And that advocacy work is absolutely critical to the Guild, to CCC, and other trade associations. And it's my personal view that those organizations are doing the best possible job they can. There's an enormous amount more to do, both in advocacy terms and in copyright education terms. And I think it's a responsibility we all have, whether as individual authors or individual publishers, to engage in that process of advocacy and education. But of course, the market has a role to play here too. And as I mentioned at the beginning, it's very, very important that we put in place services and tools and mechanisms that enable people to license your content, other authors' content, other publishers' content, as easily and as seamlessly as we possibly can. At that point, I really think I ought to stop talking and give you the opportunity to ask me any questions. I know, having been a participant in these types of webinars myself in the past, that sometimes the questions occur to you 5 minutes after putting the phone down, or 5 days after putting the phone down. So I've included my email address here, mhealy@copyright.com, and I'd be happy to take any questions in the future that you might have. Very happy to take your emails. But if any of you do have questions at this point, I'd be very, very happy to take them, and you can enter them using the chat box at the bottom right of your screen. I can see one question. Do you think that U.S. copyright law remains solid and has not been fundamentally changed by technological advances, but that the changes are really because content is easier to steal? Well, that's a great question. And it seems to me to be a question with many layers. Firstly, let's break it down. Is copyright law in the United States solid? Yes, it's solid, but it's also very old, more than 40 years old. And you think of the degree of technological change. I think 1976 was the last Copyright Act. Wasn't that also the year Apple was created? And if you think of what's changed as a result just of that corporation in the intervening 40 years, it gives you some idea of how much has changed. I think reform of the copyright law in the United States is probably overdue. I think most commentators feel that. We seem to have had some difficulty having Congress pass laws in recent years, and it's been a very sort of blocked into some would say dysfunctional Congress in some respects. But I think further reforms are coming, and there's certainly no shortage of recommendations for what that reform ought to look like. And those recommendations come from so many different places, from the Copyright Office, the U.S. Copyright Office, for example, from interest groups, whether they be technology concerns or trade associations representing authors and publishers, etc. There's never been so much talk about copyright. And as I said at the beginning, it's extremely polarized. And I think there's a lot of constituents now who would say that there's a real need for reform of the existing copyright law. One other question has come through. As an author, what should be my greatest concern internationally? That's not such an easy question to answer, because it rather depends what you as an author prioritize. If, like many authors, revenue matters, and I'm sure it does, perhaps your greatest concern ought to be declining royalties. Declining royalties from places like Canada, from South Africa, from Brazil, from Australia, if the direction of copyright law is going unstoppably in the way I've suggested. That could, taken to its logical conclusion, mean that royalties and revenues into your pockets, into your publisher's pockets, are going to decline. So that could be possibly your greatest concern. But perhaps you're focusing more altruistically than that, and in that case, you'd be more concerned, I think, about this global erosion of copyright that has protected your interests, fellow authors' interests, publishers' interests for such a long time, leaving aside the financial consequences. There is this more principled issue of, is copyright going to be eroded? And therefore, the incredibly valuable contribution it made to the creative economy, to scholarship, to teaching, to learning, is itself going to be inevitably diminished. If that's a worry, then it's certainly one that I would share. Someone else has said, I think it might be the same person who kindly contributed the earlier question, I worry about the law of unintended consequences and am therefore leery of reform. Yeah, I share that. Leeriness, if such a word exists. I think the Canada example I gave, the Copyright Modernization Act, could be a test case, a sort of textbook case, if you like, of the law of unintended consequences. I wonder whether whether Canadian legislators would have done the same thing again if they'd known how damaging it had been to authors, publishers north of the border. I don't know. Perhaps they'd do exactly the same thing again. I should have said there is an opportunity under Canadian law to review the impact of new legislation after 5 years. And of course, 2017 is the 5th anniversary of that legislation. So we'll wait to see what's happening north of the border there, and we'll see. Someone else has asked, does CCC have a counterpart in South Africa? If not, then who and what organization is advocating against the draft legislation now under review, which has some really bad elements? We do have a counterpart there. The organization is called DALRO, D-A-L-R-O. They have done all the things you might expect them to do to fight the good fight against this damaging draft legislation. And there are many, many committed trade associations and organizations, including the Publishers Association of South Africa, PASA, that have been in the vanguard trying to get the worst excesses of this draft legislation modified. You know, it remains to be seen because this hasn't been enacted yet, and we'll have to wait and see what happens in South Africa. But there's no denying that people are fighting hard against the reform, as it's known. And we're just going to have to wait and see how that goes. I want to thank you all very much for the questions you submitted. I can't see any others that have come in just now. I also want to thank you very much for participating. I hope you did find it useful. Healy at copyright.com. If you have any questions, please send me your emails after the WebEx, and I'll do my very best either to answer them myself or to put them in the hands of one of my colleagues who can help. But other than that, I want to thank you again and enjoy the rest of your day. Thank you very much indeed.